Welcome, everybody. Hi, I'm Amy Rizzo, and I'm the marketing manager for Kelleher and Holland. Thank you so much for joining us today for our very first Lunch and Learn webinar. We will be holding these on the first Tuesday of every month regarding topics relevant to business owners, office managers, human resource professionals, as each session will be focusing on a different labor and employment law issue. So before we get started, if you have any questions at any time during the webinar, please type it in the Q&A question box that is located in your Zoom control panel. We're scheduled to go 30 minutes, but we do plan to stay on an additional few minutes or so to answer any questions you may have at the end of the presentation. So let's get started. Today's topic for this webinar is employee or independent contractor. And our presenters today are two attorneys from our employment law group, Andy Bowling and Madeline Kelleher. So before I hand it off to Madeline to kick things off, I'm going to take a quick poll of our audience. Our question for today, which is, have you worked with legal counsel to inventory your independent contractor usage? So if you could answer the question on your screen, and we are going to reveal the results of that poll at the end of the webinar, and we'll tell you all about how we can help you. So let's kick it off with Madeline. Madeline, if you could tell us a little bit about why we are here today.
Thank you, Amy, for the introductions. Much appreciated. So why are we here today? The U.S. Department of Labor has proposed a new rule that will greatly impact the way companies relying on gig workers, like Uber and Lyft, do business. However, the new rule will also impact the treatment of independent contractors beyond the gig economy. This new proposal is expected to take effect any day now and will reclassify workers that are economically dependent on a company so that they are considered employees instead of independent contractors, and therefore entitling them to more benefits and legal protections. The misclassification of workers as independent contractors has presented issues when it comes to workers' rights. Employees are protected under federal labor standards and laws that prevent wage theft, while contractors are generally not protected. The rise of the gig economy work has shined a light on possible issues around the relationship between employers and those that work for them. Well, before the rise of the gig economy, businesses have used independent contractors and other contingent workers for a variety of reasons. During the pandemic, we saw a dramatic rise in the use of contractor engagements to meet demands of a mobile workforce during and after the recent pandemic. Today, we are presenting on the proposed transformational changes to key federal rules regulating the use of independent contractors.
Madeline, can you provide some details regarding the differences between an independent contractor and an employee?
Yeah, absolutely. So there are important differences between independent contractors and full-time employees, including how employers relate to these workers, how they're taxed, and the benefits and protections that they're entitled to. So with that, let's cover some of the biggest differences between contractors and employees. One crucial distinction between an employee and independent contractor is the protections workers receive when employed by a company. Employees are eligible for certain employment protections provided by the federal and state government. One of these provisions, for example, is the Family and Medical Leave Act, which allows eligible employees to take unpaid leave for specific family or even medical reasons without the fear of being let go. So these covered employees can get up to 12 weeks of work during any 12-month period and up to 26 weeks during a single 12-month period. While there are some state-specific exceptions, including portions of Illinois law, at the federal level, employers are not legally required to provide employment protections to independent contractors who can be let go at any time, as long as it's in accordance with any agreement or contract that the employer has signed. Independent contractors are typically not entitled to unemployment insurance either. So, in addition, businesses aren't required to withhold taxes from payments to contractors. Rather, contractors bear this responsibility themselves, which is another significant monetary savings for businesses.
Great. Madeline, you mentioned earlier that there were changes proposed last year by the U.S. Department of Labor to these classifications. So could you tell us a little bit about what these changes are, what the impact is, and what it means for businesses?
Absolutely. So the Department of Labor's proposed rule rescinds the previous 2021 independent contractor rule and contains general interpretations for determining worker status. The 2021 rule was much more business and employer friendly and reduced the primary factors the Department of Labor considered when determining independent contractors classification by focusing solely on two core factors. First, it would be the nature and degree of control over the work performed. And second, the worker's opportunity for profit or loss based on their initiative and or investment in their facilities and equipment. So the Department of Labor's new proposed rule returns to the economic reality test, which was utilized prior to the implementation of the 2021 rule. This economic reality test, as the name implies, determines a worker's classification by examining whether the worker is economically dependent on the employer. Specifically, the Department of Labor is seeking to implement a totality of the circumstances analysis by establishing a non-exhaustive factor test, six-factor test, actually, in which no single factor is dispositive. So the six factors include the worker's opportunity for profit or loss, depending on their managerial skill, the nature and degree of control by the employer, the investments by the worker and the employer, the degree of permanence of the work relationship, the extent to which the work performed is an integral part of the employer's business, and the worker's skill and initiative. So if these courts get deference to the proposed rule, as is the Department of Labor's hope, this could greatly affect the determination of workers' classification under federal wage and hour laws, and it could make this a significant impact on many industries, including the gig worker industry and small businesses. With this new labor proposal, millions of workers could gain employee status. The positives of being classified as an employee include better wage stability, overtime protections, the possibility of receiving benefits like health insurance, and it also avails workers of unemployment insurance if they lose their jobs. So on the other side, that there's some potential negatives, which include reduced flexibility in work schedules and less opportunity to work for multiple employers. Additionally, if the rule is changed as adopted, the changed rule is adopted, many companies may simply reduce their workforce to avoid shouldering such a large added expense, which means many may find themselves out of work rather than receiving benefits of employee classification. The rule could cost some companies millions of dollars in added expenses if adopted. For example, the number of drivers for the ride-sharing giant Uber increased 30% globally last year. This company now employs 5 million drivers worldwide, 3 million of whom operate in the United States. And those drivers are currently classified as independent contractors. But if the changed rule were adopted, many could become employees, leaving the company on the hook to provide benefits and set up regulatory compliance programs covering all of them. Small businesses could end up feeling the greatest impact. Many have increased their workforce by using independent contractors. In fact, independent contractor hires have significantly outplaced employee hires. The new rule may mean small businesses need to reconsider their business model and shift away from heavy reliance on independent contractors.
Great, thanks, Madeline. Andy, I'm going to let you jump in here now. So if you could provide some insight into the scope of this new rule and tell us maybe a little bit about some of the tests that can be applied to classify workers.
Thanks, Amy. And I wanted to wait to talk about this until hopefully you finished your lunch, because what I'm going to say isn't going to help your appetite. It would be nice if this new rule, disruptive as it can be to businesses, were the only rule that businesses had to worry about. But sadly, this is not. The United States has a patchwork quilt of different laws, standards, tests, and regulation that vary across the 50 states. And even within the various states, there are different tests that might apply to such laws as workers' compensation versus unemployment benefit eligibility. This law will be transformative, and this change in that millions of workers will likely be considered employees for purposes of the Department of Labor's statutes. And for most employers, the big statute that will be impacted is the Fair Labor Standards Act, wage and hour. And so contractors will be treated as employees under the Fair Labor Standards Act, and many already are under various state laws. But this could lead to many more claims for overtime compensation and the like. One common question that I've entertained from many of my clients is, well, what about the 20-factor test? What about the IRS rules? And the IRS has its own rules, at least for right now. The IRS, though, still uses the 20 factors, but they are encouraging employers to look at their 3 high-level factors. And they include behavioral control, financial control over the contractor relationship, and various other relationship factors. Now, the IRS website still refers to their own independent test, which is different from the new rules that Madeline has been talking about and is really the primary focus of our program. But we will see, particularly with the increased funding, most of which survived the budget negotiations, many of us suspect, and there are strong signals, that a significant portion of this enhanced enforcement budget will be used by the IRS to audit and review independent contractor relationships. There are also, as I mentioned at the opening of my comments, different state law tests that can apply. And I'm going to talk about one because many people have heard of it. It's called the ABC test. And what does that mean? Well, that's a test that really is functionally different from what the Department of Labor has proposed. In many ways, it's different and more employee-friendly than the IRS 3-factor or 20-factor, however you define it. And it is the law in several important states, including Massachusetts and California. And to be a true independent contractor in any jurisdiction using the ABC test, the business has to satisfy all 3 factors, A, B, and C. Test A is the contractor freedom from control of the business. In other words, does the contractor enjoy the discretion to set their hours of work? Does the employer micromanage their daily activities? And does the contractor provide their own work equipment and tools to do the specific job? Now, the B factor is critical because it is shared with the proposed new DOL rule. And this is the service outside the usual course of the employer's business. And in other words, if the contractor is involved in revenue generating activity, if they are doing similar activities to those performed by regular employees or by people who would ordinarily be classified as employees, it's unlikely you're going to get to step C. But if you do, the C factor is the contractor engaged in an independent trade, occupation, profession, or business? In other words, make sure the contractor is not just an adjunct to your business. We needed an additional salesperson. We needed some new hands in the factory to deal with absences or a rise in orders. Well, those contractors are functioning in roles that are traditionally discharged by employees. So that's the C test. And that can be very, very difficult for employers to pass A, B, and C.
Great, thanks, Andy. So in addition to all the Department of Labor changes that Madeline, you were talking about earlier, I know there are also National Labor Relations Board changes. So Madeline, could you shed some light on what those are and the potential consequences to those changes?
Yes, absolutely. So in light of the Department of Labor's new rule, the National Labor Relations Board, the NLRB, has recently taken aggressive steps to impose National Labor Relations Act violations on employers that misclassify independent contractors, regardless of whether the company had a good faith basis or belief that the worker had been classified correctly, as well as violations regarding employers who retaliate against independent contractors that join unions. So in May 2022, a regional director for the National Labor Relations Board issued a complaint notice of hearing, which alleged that the mere act of misclassifying independent contractors would violate the National Labor Relations Act. The rationale behind this was that there are too many individuals under company control that are not getting the benefits of an employee, as well as issues with independent contractors being able to join unions. It remains to be seen whether this lawsuit holds any merit, but regardless of the outcome, the National Labor Relations Board's effort to create a standalone violation should send a message to any company using independent contractor business models. So with these proposed violations come more time and expense for companies who should now be documenting their good faith belief as to why each worker has been classified correctly. And prior to doing so, consider evaluating their current independent contractor relationships to determine if they can enhance their level of compliance by restructuring, redocumenting, and or re-implementing such relationships in a customized or sustainable manner. Also, companies need to be careful now not to terminate or otherwise retaliate against workers classified as independent contractors, where such workers have supported a union's effort to organize them, as such may be deemed to be independent, unfair labor practices.
Great. Thanks, Madeline. Andy, I'm going to hand it back to you to maybe cover some good examples of an independent contractor versus an employee under these proposed changes.
Thanks. Another common question I get, well, tell me who can be a contractor? Andy, come on, there's got to be somebody. And I'm going to give kind of two basic examples. One, make sure the contractor is somebody's employee. If the employee is the contractor personally, or if it's their alter ego business, it's Andy Bowling LLC, and Andy Bowling's the guy who shows up to cut the grass, you need to really look to make sure that somebody is taking care of the payroll taxes and workers' compensation insurance. So if there is no objective third-party employer, look closely at the arrangement. But the landscaping example may be a good one, and it's really the only one that I can say with some level of confidence is probably likely to hold up without much scrutiny. And let's say, for example, you have a factory and it makes widgets. Anybody who is inside that factory, putting hands on the widgets, packing them, making them, designing them, calling customers to sell them, they're going to be an employee. But if the widget factory is surrounded by some strips of grass and flower beds, and you engage a contractor to come in weekly and tend to the lawn and the flower beds, more likely than not, that contractor will be viewed as not central to the business. The landscaper isn't involved in making widgets better, selling more widgets. So that example would be an activity that is not core to the business of the company. And I think when you're looking at your own relationships, you have to really go to that very basic level, because you'll be surprised at how your legitimate contractor relationships will shrink with this heightened level of federal and also state scrutiny.
Great. So Andy, tell us, after you've and Madeline have explained all the proposed changes, what's going to happen if you do not comply? What are the consequences of misclassification?
Well, there are a number of consequences across state and federal levels, but the foremost examples would be payment of employment taxes. You know, the contractor has to pay the employer's contribution to Social Security, FICA. If the contractor doesn't pay their state and federal taxes, you are on the hook for that. And employers can also face, via their owners, officers, and directors, personal liability for penalties and fines for noncompliance. The business could be liable if there's no workers' compensation insurance. If you're calling someone a contractor and they are injured on the job and deemed to be an employee, all of a sudden you have to self-fund that loss. The same thing for a contractor who is denied health insurance because they aren't an employee and aren't invited to participate in the plan. If they are misclassified and they or someone in their family has a catastrophic illness, employers could be liable for bearing all of the medical costs that would have normally been paid by health insurance. So there are a number of issues as well as legal concerns. You may think a contractor will have limited authority to create vicarious liability or to bind the company. But if they are actually an employee in the eyes of a court or government agency, what they say or do could bind the company to legal consequences.
All right. So with the 5 minutes we've got left, Andy, why don't you tell the audience what employers can do now?
And I'm going to go back to the poll because we asked the question, how many of you have actually talked with a lawyer about taking a look at your current independent contractor relationships? And less than 15% of the respondents said they had. And that is really, I think, the most important thing any business can do right now is to take a look and inventory. Where do they have contractors? What are they doing? And what documents do we have in place to memorialize the relationship? Now, you should not do this without a lawyer, whether it's your in-house lawyer or outside counsel. You want to make sure that what you're looking at and possible solutions are covered by a legal privilege, the attorney-client privilege, as much as you can. And if you just decide to do your own internal review and assessment and create some unwise emails thinking, oh my God, do we have trouble here? And believe me, Madeline and I have seen such communications without any lawyer's thumbprints or names on it. This is fodder to be handed over to the government or to a lawyer who's representing a contractor in an employment-related claim. Do that audit. Madeline and I have a really simple and easy to use, user-friendly audit process where you can take a deep look at your relationships and have that review be protected by privilege as much as the law will allow. What else can you do? In addition to that self-audit, I think it's extremely important that companies centralize the approval process to determine who can engage a contractor. Too often in big companies and smaller companies, you may have some random low-level manager hiring an independent contractor who is functioning as an employee, and the CFO may not know. The HR director may not know. And so you have these unexpected relationships and potential risks because there's not an internal governance process that regulates, we are going to be judicious and careful when we engage contractors, and all contractor relationships must be approved by, let's say, the CFO or VP of HR. The other thing, and another important driver for independent contractor relationships is, we got this salesperson and they're in a state where we need to have a legal entity or we're worried about tax risks. So we'll call that person a contractor, and then we don't have to register with the state or be liable for corporate income tax. Well, those decisions are coming back to bite companies in a significant way. And if you're in that extreme situation, I would consider engaging that worker via the third party, such as a PEO or perhaps an employee leasing company who will stand as a proper legal employer and then provide the services to you, and so that you can continue to maintain that relationship, but not bear the risks of an unintended employment relationship. And with that, Madeline and Amy and I thank you for your time, and we're here, until to answer any questions that might come in. We'll stay beyond 1 o'clock, but thank you for your time.
And we already have 2 questions submitted, so we'll get right to it since we've got 1 minute left. First question that came in is, what if the independent contractor is performing work similar to work typically performed by full-time employees, but the contractor is located in a distant city where we don't have a physical presence, and the subcontracted work is limited to short durations, 8 to 16 hours of field work? Would that pass the ABC test?
In my personal opinion, and obviously I'm going to be lawyer-like and say we need to look at the big picture, but my initial reaction is no. Because in states that use the ABC test, they do it for a reason. They think that employers are trying to play fast and loose with existing rules, that the state's being deprived of revenues in the form of their full tax contributions. The new rules are really focused more at the nature of the work and not on whether this is just a casual one-off engagement. If people are performing work that would normally be done by an employee, but they're in a different location and doing it just for a short time or on a casual basis, they are likely employees.
Great. We have another question came in. What about a general contractor that hires subcontractors? Do they need to worry about the subcontractors being classified as employees?
Yes. And there are 2 reasons. One, there are all of the laws and rules that Madeline and I have talked about. And then there are states such as Illinois, which has particular statutes that impose increased burdens on general contractors who ultimately bear the ultimate responsibility for misclassification of a subcontractor's employees. You have to make sure your subcontractors are engaging their personnel in an appropriate way, providing workers' compensation, insurance, doing all of the payroll requirements. So yes, a general contractor has even more to worry about. And again, the safest course is to use a reputable subcontractor who has heft and who and who will gladly share that, yes, we are paying workers' compensation. We're withholding taxes from compensation paid to our employees. So it's extremely important.
Great. That is all the questions we have submitted so far, but feel free to contact either of our speakers today if you have any additional questions. We are having our next Lunch and Learn. As I mentioned, these will be monthly, every Tuesday, but due to the holiday, the next one will be on July 11th. And it will be about the importance of updating your severance and confidentiality agreements. So be on the lookout for more information about that. And I would like to again thank our audience for listening. Again, you can follow up with Andy or Madeline directly if you have any additional questions. Thanks for joining us.